So, Deputy Catherine Murphy.
Thank you. And I too have tabled an amendment seeking a sunset clause. I think there's probably several of them. And if the general scheme is to supersede this piece of legislation and others, I would have thought that it would be self-evident that a sunset clause would be the kind of safeguard that that would be the minimum that we would expect. I think it needs to be stated very clearly that if this bill passes, we'll be making mistakes, and many of the mistakes in the legislation can be foreseen, and I'll come back to a couple of those later, but there'll be inevitably ones that that we won't see coming. But the shorter duration there is for this piece of legislation, the less likely that is to manifest itself in on a constant basis. Really, again, I will reiterate the point in relation to scrutiny. This is not the way to do legislation. There's just been no oversight for this bill. And that's not the fault of the Justice Committee, it's not the fault of the Data Commissioner, who did their level best with the time allowed, but truthfully, they've been really shouting into the wind. The way the Department of Justice has handled the introduction of this legislation really makes a mockery of the concept of oversight. There really isn't oversight. Following the 2016 decision by the European Court of Justice, it was clear that the way we were retaining data in Ireland was a complete breach of European law. The Murray report in 2017 found that the original 2011 Act amounted to the illegal mass surveillance of virtually the entire population of Ireland. A vast amount of private communications information is retained without the knowledge or consent of the people that it's been retained on behalf of. The data shows who we speak to, where we're going, and what we're interested in. The Murray report also made a number of clear recommendations on how we should bring ourselves into line with the law. Those recommendations are not reflected in this bill. In 2017, the Justice Committee conducted a pre-legislative scrutiny on the general scheme of the 2017 draft bill and made a number of recommendations on how to bring the legislation in line with the law. Those recommendations are not reflected in this bill. After 5 years of successive Ministers for Justice sitting on their hands, essentially, we're in a position now where emergency legislation is required. And this bill has been fast-tracked through both houses on the basis that it's an emergency, but it's an emergency of the government's making, both this government and the last one. This time around, the Minister requested a waiver of pre-legislative scrutiny, attempting to circumvent scrutiny of legislation which affects the rights of every person in this state. That wasn't granted, but from the Department's point of view, it may as well never have happened because nothing said at the meeting was reflected in the legislation, and it was never going to be. The bill was published last Friday after a day after the pre-legislative scrutiny committee report stages are scheduled for tomorrow. There is clearly absolutely no intention to take on board the very serious concerns raised by members of this House. Very concerningly is the disregard for the Data Protection Commissioner's role in being mandatorily consulted by the Minister for Justice under Section 84(12) of the Data Protection Act 2018, and that's my reading of it, on any proposal for a legislative matter that relates to the processing of personal data. You might just confirm that, Minister. The Deputy Commissioner of the DPC, Dale Sunderland, told the Justice Committee last Thursday that the DPC had only received the general scheme 8 days earlier and had not submitted its observation to the Department yet because the Department had advised that there were significant updates to be made. The DPC received an updated copy less than 24 hours before appearing before the Justice Committee and less than 48 hours before the bill was published. The DPC had to brief the committee on their feedback for the general scheme, which at that point was already outdated, but they did not have enough time to prepare a response to the updated bill. This is just ridiculous stuff. And this is the kind of thing that happens. And you can pick the dates every year we're going to see this kind of thing, and it tends to be 2 or 3 weeks before the summer recess or just before the Christmas recess. And it's almost like it's a management tool to get things through at breakneck speed that are unpopular or dangerous. There was no meaningful consultation with the DPC at all. Sending them the bill in advance is not consultation. This is a dangerous lack of oversight on this bill relating to the state's continued operation of the clearly illegal power for years after it was made known, damaging the rule of law and undermining prosecutions which can be thrown out on appeal because of the manner in which the state has retained information. The government has admitted that this bill is not adequate. Another bill is going to obviously follow later this year, and I'd ask the Minister to ensure that the process surrounding that bill are sound and that stakeholders need to be consulted and recommendations from the Murray report and the Justice Committee need to be taken into account. We need to get an assurance from you, Minister, that is how this is going to be handled when we see the general scheme coming before both the committee and before this House. For this reason, as I said, I've submitted an amendment, as has others, in relation to the sunset clause to ensure that the revision of the Communications Retention Data Act 2011 is done in a timely manner. This bill doesn't scratch the surface of what needs to be done in order to bring the data retention systems in line with EU law. It doesn't provide an explicit exemption for journalists, clear oversight mechanisms or compensation to persons whose rights have been violated. Critically, it also doesn't ensure that prosecutions against criminal groups through the use of this data won't be thrown out on appeal, because data collected under this bill will simply be improperly collected. Under the new Section 3A, 1-year data retention orders are given out in all cases, completely against the Court of Justice for the EU ruling, or against the CJEU ruling, that the duration of each data retention measure cannot be systemic in nature and have to be limited in time to what is strictly necessary. Data retention orders need to be assessed individually. This system of blanket 1-year retention orders, which can be renewed indefinitely, is completely out of line with EU law. When it comes to the need to retain data for national security reasons, this bill leaves out one fundamental detail, which is the definition of national security. By including a broad and undefined term such as national security, it again falls short of the court's requirement of proportionality. It is very clear under the European law that legislation we adopt on data retention must have clear and precise rules governing the scope and application of the data retention measures, and must be limited to what is strictly necessary. By not defining which events or acts constitute a threat to national security, we are granting the Gardaí an almost unlimited degree of discretion in terms of determining what is a threat to national security and whether that threat is serious enough to justify secret surveillance of individuals or groups. That is a situation is rife to abuse, Minister. The Murray Review was originally commissioned on the back of the discovery that GSOC had obtained the phone records of 2 journalists without their knowledge or consent as part of a criminal inquiry into a third party. So it's very hard to comprehend how this bill, 5 years on, fails to provide for the protection of journalist sources. It is a requirement under the ECHR that surveillance aimed at identifying journalistic sources must go through a heightened screening process, including prior independent judicial approval, before any information which could identify a source is handed over, regardless of how urgent the situation is deemed to be. The oversight mechanisms in this bill are simply not up to scratch. The ECHR requires that all surveillance measures must operate under objective supervisory bodies which are completely independent of the authorities carrying out the surveillance and must have sufficient powers and competence to exercise effective and continuous control. Instead, we have a proposal which a designated judge with no technical or legal expertise in the area of data protection, no administrative support, no power to suspend illegal surveillance, and will only carry out this function on a part-time basis once a year. The Murray Review found that there should be an appropriate judicial remedy for breaches of rights under our data retention system. This is not included in the bill. I do have overall concerns in that this bill attempts to retrospectively validate the illegal retention of data contrary to EU law. Section 9 requires providers to continue to retain data that it is acknowledged is currently being held illegally. By doing so, it is retrospectively validating the illegal retention of data. I understand that there are a number of cases still to come in relation to the retention of data under the 2011 Act, including one by Digital Rights Ireland, who have also made a complaint to the DPC seeking it to take enforcement action against providers, requiring them to delete data which has been retained illegally. I would ask whether the Attorney-General has given advice as to how this will not come into conflict with the Sinn Féin funds principle, which found that the state can't legislate to determine something that is currently before the courts. It would also undermine the independence of the DPC by interfering with the power to act in relation to the pending complaint, contrary to Article 52 of GDPR. The DPC have raised significant concerns with this legislation, and it's simply not acceptable for the Department to have completely bypassed them in the drafting of this bill. In light of what they deem to be high risks to the rights and freedoms of data subjects under this bill, the DPC stated very clearly that the Department should have and still should conduct a data protection impact assessment in relation to the processing and provisions proposed. It is absolutely fundamental that this happen prior to the drafting of the new legislation later this year, especially if the government intends on retaining the processes outlined in this bill. You might give us a response to that, Minister, about what your intention is in relation to that. The final concern I'll raise in this bill is the offences contained for service providers who don't comply with the legislation. It creates both a 72-hour and 90-day obligations on service providers subject to a threat of sanction or offence if not complied with. The list of offences includes fines of up to 500,000 and 5 years imprisonment. All of this was not communicated to service providers prior to the publication of the general scheme. They should have been consulted in advance to determine whether it was possible for the telecom companies to comply with the legislation within that tight time frame. In 3S submission to the Justice Committee, it's quite clear that they can't. And given that the bill contains additional specified categories of data which need to be preserved, 3 estimated it would take them between 12 to 18 months to set up the necessary IT projects. Presumably, within that time frame, the new legislation will be in place, which could very well contradict this bill. Service providers need assurance that they will not face a threat of criminal sanction for non-compliance when there is simply no way that they could comply at all. and they also need assurances that they aren't going to be spending money on new IT infrastructure, which they'll have to scrap within a year when it's determined that actually this legislation doesn't conform to EU law. There are serious concerns with the way the state collects data. It's illegal and it infringes the rights of every single person in the state. I don't see any way in which this bill remedies the situation, but see several where it actually makes matters worse. I've absolutely no doubt that we'll be in this chamber in a number of months correcting the mistakes in this legislation, and will have been an absolute waste of everyone's time and effort. I would ask the Minister to introduce this sunset clause. I think that's the very minimum that we should expect. I also think that there is very often there's a presumption that domestic law in all situations trumps EU law, when that's not the case. And our Data Commissioner has a particularly important role, given where we're positioned in terms of our Data Commissioner as it relates to, as that office relates to other jurisdictions across Europe. And I really do think that we're treating that office with a great deal of disrespect, and not just disrespect but contempt in terms of not including them in the process, but merely sending them a copy of the bill to be, and that's to be taken as consultation. It's just not good enough, and I think that there's no doubt that there's going to be mistakes made that we'll see the result of before the new bill comes in front of us, and hopefully that will come sooner rather than later. Thank you.